Welcome guys to Buying South Florida on Air. Today I'm excited to have Laura Lavie. She's our trusted estate planning attorney. Laura has almost 2 decades of legal experience in estate planning and administration. Laura is barred in New York State and in Florida. Extremely knowledgeable, very transparent, easy to work with. I'd refer her with full confidence. Laura, welcome.
Mario, thank you for the very nice introduction.
Yes, absolutely. Thank you, Laura, for spending some time with us. So tell me about this CNN interview you did.
So one of my clients actually works a lot with CNN Dinero, and a very interesting case having to do with a tortilla magnet that came into the press, and I was asked to consult and give my opinion about it with the host of the show. What's interesting about this case highlights something that happens to people even that don't have millions and millions of dollars, which is that sometimes they do things on their own thinking that they are fixing a problem, and in fact they're creating a bigger problem by doing something without professional advice. So in that case, I think it was years ago that I gave this interview, but there was a former spouse that claims that she was never really divorced from the guy that passed away, and he had remarried a woman in international waters. So there was a sort of a dispute of who was entitled to part of the estate. And people have a lot of intentions. People, no matter how much money you have, or what you've inherited, or what you've worked for your whole life, everyone has a very strong view of who should benefit from that. So any person that has anything that they want to make sure that it goes to someone that they love, or charity, or what have you, should really consult with an expert, because a lot of mistakes get made with a lot of unintended consequences are made by trying to do these things yourself.
Yeah, I bet. So I don't know if you can speak about the case or not, but I'm assuming someone wanted to leave someone else some tortillas and they couldn't. Is that what happened?
I didn't personally work on the case. I wasn't involved in the case, and I read an article about the case. And generally speaking, it was who was entitled to the estate. Was it the new wife? Was that a valid marriage? Or the former wife? Were they still married, or had there been a divorce? I think was a central issue.
So what exactly is estate planning per se, right? So I am completely new to this as you know, I've asked you a million questions before and so forth, but to someone who is completely new to what estate planning is, can you tell us exactly what it is that you do?
Sure. So many people have the misconception that you need to have millions and millions of dollars in order to plan an estate. An estate is simply what you own at the time of your death, be it bank accounts, a car, a family heirloom, a piece of artwork, a brick, whatever it is, that is your estate, okay? And so what I do is I assist people in planning on the distribution of those assets after they pass through the creation of wills and revocable trusts, depending on the situation. And also, I help administer people's estates once they've passed by going through the probate process, or administering trust agreements by representing trustees and fiduciaries and personal representatives in probate matters. And another aspect of what I do, which is very important and what people really definitely do not think about, which is probably now at the forefront of everyone's thoughts, now that we're all at home dealing with the fear of what's going to happen with coronavirus and having people that we know affected and love and become ill, is estate planners also prepare documents in which a person designates someone else to make medical decisions and also financial decisions for someone in the event that they're still alive but unable to take action for themselves or make decisions for themselves.
So when should someone create an estate? The reason I ask is because we deal a lot, or me in particular, because I deal a lot with a lot of first-time home buyers or investors, right? So is there a time or an age that someone should create the estate?
I think every adult, starting at the age of 18, should start with a very basic set of documents, including a power of attorney, a designation of healthcare surrogate. As you know, in this country, there's laws prohibiting medical providers of giving private medical information to people that are not designated by you. So I've had clients, for instance, that have, college-age children over the age of 18 that have gone on ski trips to Colorado and have broken a limb, and they have not even been able to get confirmation from the hospital of what's happening with their child. So another thing to mention is that estate planning is really a dynamic process. Just like in life today, we weigh a certain amount, we may have a certain amount in the bank, and we're a certain age. All these things are going to fluctuate over time. Our desires are going to fluctuate over time. And not to mention, there are tax laws that change over time, and family situations that change over time, and personal situations that change over time, and relationships with people that you might name that change over time. So these are things that are dynamic and should be reviewed from time to time.
Gotcha. So, we come across the type of ownerships often, right? In my line of work, where a client comes in and wants to purchase a property under an LLC or under a trust. Can you kind of just touch on the difference in single member LLCs as compared to a trust or maybe personal ownership of properties?
So I don't specialize in corporate law or real estate law, but I can tell you that one of the most common things that people own is real estate. Usually people acquire real estate, many people acquire real estate, bank account, and maybe nothing else in their lifetime, but that's something that they have. I also should mention that anything that I'm saying is related to the practice of law in Florida. I'm licensed to practice in New York and New Jersey as well, but I'm directing this conversation only as to Florida law. So I just wanted to make that disclaimer for your viewers.
Disclaimer, got it.
Okay, so in Florida, there are lots of laws that protect people when they have a homestead property. And homestead has various meanings and various benefits. And there's limitations on homestead. But basically, most people that have a primary residence in Florida can claim homestead. This means more than two things, but two important things and two important concepts is that your homestead is protected from the claims of creditors unless it's the IRS or the bank holding the mortgage.
Yep, that's big.
And it protects your family members because it's a non-probate asset and it passes outside of probate to your spouse and children. However, that being said, you still need a court order to determine that a property is homestead, even if you have been getting a homestead exemption from your taxes for many, 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 many years.
Really? Oh.
Yes.
So, but with a will, so if someone passes away and they leave their homestead to their kid, is a will enough, or do I have to do some type of estate planning?
So I think that when people that, you asked me before who should start contemplating estate planning. And I mentioned that any adult over the age of 18 should really have some basic set of documents designating other people to be able to make decisions for them in case something happens to them. They're in a car accident, they're ill, they have a hospitalization. Many things can happen. And one example that I give a lot in South Florida is that here people drive like maniacs, and almost every single person that we know has at one point been in a very devastating car accident where thankfully many people survive, other people don't, but could have an extended hospitalization. So this is very important. And when I counsel couples and they only want to name the other, I often say, well, do you ever go to your dinner with your partner, the movies with your partner? Are you ever in the car with your partner? Because what happens, you could both be in an accident together. Yep. So not only do you really need to think about who you really trust and who can make the best decisions for you, but you need to think of alternates as well. Once people have children, and in this day and age, many people have children that are unmarried. They have children with a partner, without a partner, on their own. Certainly when you have children, you definitely want to focus even more on your planning, because the only way to name a guardian should something happen to you is in a will. A lot of people, and I know because I've been doing this for nearly 20 years, they like to postpone the estate planning conversation until like a critical life event happens, like, oh, I'll do it when I'm married, or I'll do it when I do this. And you know, when you do that, when you postpone something, you'll always find a time and place to postpone. But when you have a will gives you the right and the ability to name who administers your assets when you die. But these are just the assets that don't have beneficiaries already designated or joint owners on your property, like a bank account or your husband owning
like
property.
A business bank account, for example, right? That doesn't have beneficiaries or a real estate property that is under an LLC. That would have to be named in this document, right? Because they don't have beneficiaries in LLCs or corporations.
Well, one of the things that people often think is that they come to me with a list of everything they own, and they want to divide it equally amongst 3 children, let's say. And so they've tabulated every asset that they own and the net worth of those assets, and they've divided the assets in accordance to the values at that time. And that's not really a great way to do it, because, as you know, assets could fluctuate in value, properties can fluctuate in value, bank accounts can fluctuate in value. You might sell a property, you might do other things. So it's really more of a general document that says, I give, X, Y, and Z, 1/3, 1/3, 1/3. Or, I mean, there's many ways to do a plan and to effectuate a plan to make it as streamlined as possible for a particular person. So I caution people, there are many people that say they do estate planning. You really want to go to someone that really does this, not only the planning part, but the implementation of administering an estate afterwards, because you want to make sure that as you're planning something, you know how at the other end that it's actually going to work. And unfortunately, with a will, you don't really know until the person dies whether the person did a good job or not. So
unfortunately, right.
So yeah, so you want to work with should work with a practitioner that understands the questions that need to be made, questions that need to be asked, that basically asks you lots of personal questions, gets a little bit nosy, and is able to determine and give you the best advice. Because also, it's very, very difficult to go to a professional. It's very intimidating. You don't know this person, and meanwhile you're being asked about your family, your money, everything. It's a very personal situation. So the person really has to feel comfortable. The professional should really engender confidentiality, but rapport. And you should feel comfortable that the person's going to take care of you and really ask you the right things and be able to provide the advice that you're really seeking. Because sometimes people come and they say, I need this. And I say, well, what are you really trying to do? Because, someone could say, I need a trust, and I can create a trust for them. But I really am more interested in what is it that they're trying to do, because the people that are asking me are not trust lawyers. They might be lawyers, they might be plumbers, they might be, they might be stay-at-home moms, they might be teachers. They might be very, very bright, but they don't deal with trust on a daily basis.
Yeah, and actually one of the questions I recently had for you, I think a couple of days ago, was that a client of mine is purchasing a second home, and he wanted to protect it by putting it under a trust. So he asked me if he can put it under an LLC. So doing a conventional or FHA mortgage, you can't purchase a property under an LLC or a corporation or anything like that. It has to be either under a trust, a revocable trust, or under your personal name, which is the most common. So he asked me if he could buy the property under an LLC. I, of course, told him no, he couldn't do that. He could then buy it under a trust or his personal name, which then I came to you with the question, how is he protected, or how much more is he protected if he buys his property under a trust versus his personal name?
So when you approached me with this question, I suggest that we have a conversation, because I had a lot of questions. And the most important thing is, what's the intention of this person? What is it that they want to accomplish, that they think they need a trust? So in this case, they wanted protection, and they aren't able to put it into the name of an LLC because they can't get the financing necessary to accomplish a transaction. And I said, well, what is it why does he want to do it in an LLC if they want protection? I said, well, putting it in a revocable trust is not likely to give the protection, because I've had clients before that have attempted to get mortgages via an irrevocable trust, and they weren't able to get financing, the same kind of financing. A revocable trust avoids probate and has certain benefits and a lot of utility, but doesn't protect you from creditors. It would be the same as them having it in their own name. And most likely, if the person was going to be the trustee of their own trust, even if they named it a 1, 2, 3, 4 trust, they'd be taking title in their personal name as trustee of the 1, 2, 3, 4 trust. So if that is what they were trying to accomplish, then doing a trust really doesn't do what they want. It would create an added expense and not accomplish what they need. That being said, if they don't have an estate plan, I would encourage them to speak to someone that could help them, especially if they have investment real estate.
Yeah, and obviously I'd had that conversation with them about, it's a absolute must that they sit with you and they go over their entire, financial portfolio per se, right? And see how you can protect them and so forth. So that conversation I definitely had with them. And I really hope to bring them to your office or via Zoom soon so that you can have that conversation with a client. And I know I wouldn't trust anyone else more than you to protect them adequately. So, that is a question we often get, right? Many clients think that they can just purchase a property, put it under a trust or an LLC. And then what we find is that the ones that purchase the properties under an LLC, they'll put it under a single member LLC. And can you just really quick touch on a single member LLC?
Interestingly enough, as an estate lawyer, when I'm working on the probate end or the administration end, you end up seeing what a lot of people do. A lot of very well bright and very well-intentioned people try to do things on their own to try to fix up what they think is a fix to a problem or avoid an issue, when in fact they could potentially make things worse. In South Florida, there's a lot of real estate investors. People from all over the world love to invest in South Florida. And one of the things that people like to do that I see that is sort of a cautionary tale is people will put together their own LLC. They'll be the sole member of their LLC. And in Florida, a single member LLC does not give you any creditor protection, okay? So now that you don't have any creditor protection, what people also do is they start putting more properties into the LLC. The utility of using an LLC to own real estate is to shield the value of that particular asset from all other assets that you may own. So and I'm not an expert in real estate transactions. I work with real estate attorneys to accomplish the best structure, and usually it involves speaking to the person's CPA, because every single person has a different tax structure, and creating LLCs could create different tax return requirements and reporting requirements with the IRS. Now, when it comes to another thing that people love to do is they love to deed their property to other people.
So before you go into that, what would be better than a single member LLC? Would two or three member LLC accomplish what the client is aiming to do?
So that's a good question, but there's really not one answer to that question, because every single person has a different objective, different risk tolerances, different partners, it depends who they're doing the deal with. Are they doing it alone? Are they doing it with other people? So it really, really makes sense to have a more than one member LLC. And it also makes sense that a corporate attorney prepare an appropriate operating agreement, which states the rights and obligations of the members and what happens to a member's share should they die. Many people have handshake agreements. They hand money to each other, and it could be two best friends that have been doing it for 30 years.
Or husband and wife, same thing.
Well, let me give you another thing that I see often where it's really bad things can happen. So two buddies since college have been investing in real estate. They've made lots of money together, and they basically have a handshake deal. Their arrangement works seamlessly. I don't want to call it a partnership because I don't want it to denote any particular corporate structure, but the way that they do things has been working beautifully over the years. And what happened, and maybe one of them gets into some sort of legal trouble, so they start titling things in the name of one partner, but they know what percentages each really owns and how much each person really put into those properties. Well, what happens if one of those two guys or females passes away? The spouse may not have the same kind of relationship or even understand the arrangement that the spouse had with the other real estate investor partner. So this can happen because the way that you title property has legal significance. When someone passes away, when something gets sold, when something gets transferred or gifted, and who has the right to sell or encumber the property. So these things are really, really important to be done correctly, because at the time that someone's trying to do an investment, they think they're getting a great deal, it's a great investment, and they're not thinking multiple steps ahead of like, what happens if I get divorced? What happens if I die? What happens if my partner dies? Can I get along with my partner's spouse? What about their children? What about, if you have an operating agreement and it's done properly, then everything's in writing. So the rights and obligations are very specific, and there's not a one-size-fits-all agreement. I've had clients that are real estate investors, and the patriarch of the family is like super controlling, wants to control from the grave, and I've prepared documents which, with the real estate attorney, they've done and corporate attorney, they've done the operating agreements of like, what happens if this patriarch can't make decisions? What's the priority of who makes decisions in the because when you use a trust agreement, you can assign a membership interest in an LLC under your trust. And so it can be very, very specific, but you need to be with the right people. You need to meet with the right people that can create the plan that you really want, and that's really going to work under your circumstances.
Gotcha. Yeah. So it's you bring up a lot of I don't know if the word is red flag, but a lot of light bulbs, right, are going off right now, because obviously, we come across the ownership types often, and again, we don't give legal advice or anything close to that, right? But I do understand a little bit about the different types of ownership and things like that, and everything you just explained, it's like, it's so alarming, I guess the word is, right? Because there's so much more to it than just, hey, I'm investing with my buddy, I'm just going to put this under an LLC with him, and that's it, right? And then top it off, we do that 5, 6, 7, 8 times, and we own 10, 15 properties, and okay, now what? So it's alarming. It brings up a lot of ideas and a lot of things that we need to do. I mean, the underlying idea that comes to mind is everyone should be speaking to you regardless of age, regardless of how many investment properties they have, and so forth. So I'm definitely going to be pushing more the conversation to go to you, right? This is something that needs to be done. It's one of the most important things, the ownership. What happens when somebody passes? What happens when somebody's bedridden, like you said, right? And there's a disgruntled spouse, or there's a disgruntled brother, or something like that. So yeah, absolutely. Wow. So couple of things. Let me just
add one thing.
Yeah, of course.
I think a key takeaway for a professional that deals with a lot of people buying real estate, whether it's their first home or their 20th investment property, is that you can add a lot of value by getting them involved with the professionals from the beginning. I find that when people are well informed, if they want to make their own mistake, then at least they know they've made the mistake. It's not like they're unintentionally making a mistake. And there are certain people that will just do things their way, and they just think that, like, it'll be okay. And sometimes it is, and sometimes it isn't. But a lot of people, knowing the consequences, are willing to invest in doing things in the right way, which is scalable, but they know that they're protected, and they know that their families are protected and their assets are protected.
Yeah, and it's you spend you spend a little bit of money up front, right? And it's not so much spending it, it's more of an investment you make to protect your investments, right? As opposed to try to do it yourself, create a bunch of single member LLCs and you did nothing but spend money unnecessarily, right? So three, if you can summarize into, I know it's tough because there's so many things, there's so many moving pieces, there's so many conversations to be had, but three top benefits of estate planning.
Okay, so I'm going to say why there's 3 top benefits of using an estate planner when you're contemplating investing in real estate. Okay, number 1, you want to prepare for what happens if you need to close a transaction, but you're unable to sign because something has happened to you. You can already authorize someone, or you're going on vacation, you get an amazing opportunity to travel over the world. You give someone else the power to contract on your behalf. You can do that with the power of attorney that an estate planning attorney can prepare for you. That's number 1.
Oh, and really quick, you had something now, right, with this virus that's going on that I think you mentioned right before we got on that you had your first COVID-19 situation, right? Was it something related to this?
No, unfortunately, someone passed away and they were given my name, and the decedent actually was pretty organized. They don't have a will, but I haven't had very extensive conversations, but it appears that the person's pretty prepared and the family actually knows like where things are at least, so I can assist them in getting to where they need to be.
Good.
A second takeaway is that if you own real estate, if you own it in your name, if you own an LLC interest in your name, if you pass away, that property in your name or in your LLC name will have to go through probate. In the state of Florida, unless you're an attorney, you're going to have to hire an attorney. The laws are very favorable for the lawyers that take probate cases. Now, not every lawyer knows how to handle the real estate transaction probate. And that's where title companies are very, very key. But there are many requirements that the courts impose to protect the beneficiaries. So you want to be able to minimize your exposure to probate when appropriate. And an estate planning attorney can assist you with creating trust agreements or other ownership structures, which avoid the probate and having things tied up in court and an unnecessary major expense of time and money. And lastly, please, please, please don't do it yourself. Anything that look, everyone is great at certain things, but if we're not a dentist, we don't pull our own teeth, we don't do our own cleanings, and we don't do our investments. There are other people that are very well qualified and have a lot of experience in assisting you with these types of matters. Please use them. It would be very much worth your time, money, and effort.
Awesome, Laura. Thank you so much for the class, right, in estate planning and so forth. So I'm really looking forward to bringing you more clients. I mean, you've opened up so many ideas, so many light bulbs lit up. The importance of having someone just at least have the conversation with you is phenomenal, right? So appreciate it. Thank you for your time. Thank you so much for being on here for like half an hour or so. So thank you for
the opportunity. Thank you so much.
You got it. Bye. Stay safe.
You too.